Hello, so this is the video for the AO3 of diminished responsibility. Now, you would need to know this if you had an essay question with OCR. So it's 25 marks for an essay question, 10 marks for the AO1, watch my previous video, and then 15 marks for AO3, which is your evaluation. Now, this is not a set list of things that you have to get in. You may come up with your own evaluation points. You may come up with points better than mine, which is absolutely fine. But these are some of the things I thought that are worthy perhaps of discussion. So first of all, there's a discretionary life sentence. Now, this is fairer on the defendant because the judge doesn't have to give a mandatory life sentence. Remember, with murder, the judge has to give a life sentence. Discretionary life means that there are many more sentencing options available to the judge. So the defendant doesn't even have to go to prison. If they're violent and a danger to society, then definitely they can go to prison for life. However, if it's a battered woman, for example, the judge may decide that because now her husband or wife is dead, then there's no need to put the offender in prison. So that's a good thing, discretionary life sentence. However, just to counter-argue that point, some people may believe that manslaughter is a kind of soft option and that they got away with murder, and they would believe that a manslaughter conviction dilutes the seriousness of a killing, and there's no justice available for the family. So you can argue against your points, you can state a point, you can think about the weight of your argument, think about what somebody might say to counter-argue that point, and that's fine. Put that all in an essay. That's high-level evaluation, which is great. Now, the second point that I think is unusual in law, but it's very important to discuss, is the burden of proof. Now, criminal law says that the defendant is innocent till proven guilty. This is one of the fundamental legal principles. Article 6 of the ECHR, that's the European Convention on Human Rights, says that everybody has the right to a fair trial and there is a presumption of innocence. Now, the issue we have with diminished responsibility is that the defendant has to prove the defence. This only happens in two defences, insanity and diminished responsibility. Every other defence, what happens is the defendant says, I was intoxicated, prove I wasn't, and the prosecution, beyond all reasonable doubt, have to prove that. But what we've got with diminished responsibility is the burden is on the defendant. That could be breaching Article 6, and it just seems rather unfair and unusual. So there's inconsistency in the law. Okay, another discussion point is the abnormality of mental functioning. So that first element that you have, it's quite difficult to establish what a reasonable person would find as an abnormal state of mind. I mean, juries have to sit there and listen to complex medical evidence. They will listen to a medical expert that's been chosen by the prosecution. They will then listen to a medical expert who has been chosen by the defence. These medical experts are very expensive. They are not the defendant's doctors necessarily. They are chosen because they're experts in their field. So they're going to be looking at conflicting medical evidence. It's very complicated. The jury are not doctors, yet they have to sit there and listen to details about whether this person is suffering from schizophrenia or paranoid delusions. This part, though, is limited, which is good. So abnormality of mental functioning, I've said some limits are applied because the abnormality has to be a recognised medical condition. So they're trying not to let people abuse it and say, oh, abnormality of mental functioning. So this term is flexible. It means as conditions are discovered, like battered woman syndrome, they can be added, which is good, I think. It provides flexibility in the law. It allows the law to stay up to date with modern society. However, some people would criticise the fact that there are a wide range of abnormalities, and they would say, defendant, again, getting away with with manslaughter, getting away with murder and only being convicted of manslaughter. So that's something just to consider. The other issue, substantially impaired, that this word substantial, and if you remember, we looked at a case where the judge said the jury don't need to have the word substantial defined. It's an everyday word, it's fine, they understand what it means. But how does the judge know whether the jury truly understand what the word means is? You can't question the jury. And do the jury feel confident to ask if they don't know what it means? So substantial means, when I think of substantial rainfall, I think that means there's going to be a lot of rain. I don't want to be going outside when there's substantial rainfall. But in law, substantial means more than trivial. Substantial rain, there's more than a little bit of rain. Don't know, I just find that a strange definition. So again, something to think about. You don't have to agree with me, but just argue against me. Okay, the other big issue I think we have with diminished responsibility is intoxication. So I think it's good, it's fair that you cannot have diminished responsibility if the defendant is just drunk or on drugs. You've got to take responsibility for your actions if that intoxication is voluntary. So go with the intoxication defence, perhaps. The law does accept that people are addicts, so I think the law is adapting to modern society, and it's saying people can have alcohol dependency syndrome and they should be allowed a defence. I do think there are some moral issues here, personally. I think if a defendant who smokes weed and they have a paranoid personality disorder, I'm not sure they should be allowed a defence if that drug makes their condition worse. But the law says that they can, the jury can decide what they want, but the law says in theory they can have a defence. And I just think, well, think about the victim's family in this situation. That's what you've got to remember, is somebody has died here. Now, in essays, they like you to mention reform of the law. You can come up with your own ideas. That's fine. Suggest a reform. If you think you could do it better, and quite frankly, you probably could in a lot of legal areas. If you think you could do it better, make a suggestion. That's absolutely fine. It is always quite good, though, to mention Law Commission reports, because they are the main law reform body in this country. And if there are no current proposals, just state that. Say that, well, Parliament must be fairly happy with the law because they're not looking at reforming it. The Law Commission are not preparing a report on it. Therefore, it suggests there's no big issue with the law. What I would say about diminished responsibility and reform, I would say the Coroners and Justice Act is fairly recent. It's 11 years old in law, that's recent. So it's still developing. The fact that there haven't been a lot of appeals suggests it's working well in practice. It is clearly structured. The Act explains what has to be proved by the defendant. However, certain injustices still remain. One of the issues, and I think it mentions this in the textbook, one of the issues to consider is a 10-year-old in England is criminally responsible. The age of criminal responsibility here is 10, which is very young compared to other countries. Now, a 10-year-old's brain is not fully developed, but that does not come under the definition of abnormality of mental functioning. So being very young, being 10 years old, makes it probably quite unlikely that you could actually use the defence. Okay, so that's something just to bear in mind, perhaps as a final evaluation point. But you may have plenty of other evaluation points. Go for it. Just try and really develop them. It's better to have 5 or 6 really well developed points as opposed to 15 very brief ones saying, oh, it's not fair. It's like, explain why it's not fair. What is your problem with that case? Why do you feel there has been justice or injustice? Evaluation can be good things as well. We don't have to just criticise. Okay, so hopefully that's given you some ideas as to what you would put in an essay. So an essay, remember, AO1, legal knowledge, AO3, evaluation.